Fury said to a mouse that he met in the house, "Let us both go to law, I will prosecute you. Come, I'll take no denial, we must have a trial, for really this morning I've nothing to do." Said the mouse to the cur, "Such a trial, dear sir, with no jury or judge, would be wasting our breath." "I'll be judge, I'll be jury," said cunning old Fury. "I'll try the whole cause and condemn you to death." Well, that was The Mouse's Tale in Lewis Carroll's Alice in Wonderland, which presages the later famous trial about the who stole the tarts. Some might say it also presages the modern administrative state, where often you get a trial without a jury and without a real judge. Well, the Fifth Circuit said recently that sometimes you actually do get a jury and a judge. And we'll talk about that case this week, plus a case from the 10th Circuit about general searches. This week, here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Wednesday, May 7th, 2025. It is an exciting show today because we have first-time guests, an attorney at the Institute for Justice, and also an old friend of ours who is not old. I need to add, is not old, but she is an old friend of ours. You longtime listeners will recognize her voice on the show. We are so excited to have her back. So I will introduce her in a moment. But first of all, we have Jessica Bigbie. So Jessica just joined us at IJ earlier this year. She is a grad of Florida law. She works at our Austin office in Austin, Texas. And she also spent a number of years as a public defender. Now, being a public defender is a job many of us at IJ laud. Like, that is really the Lord's work, that you were doing that job, helping the accused who can't afford their own attorney. But very few of us actually would have the gumption to go out and do that work, especially just out of law school. But that's what Jessica did. So Jessica, tell us a little bit about public defender work. Is it what we think it is? Is it better? Is it even harder than we may imagine? What's the story?
Yeah, all of the above. I'd say it is simultaneously one of the most rewarding jobs you can have, and also probably one of the most soul-crushing as well. Yeah. The highs are very high and the lows are extremely low. You know, you get to know your clients as human beings when largely society no longer sees them as such. And, to see how they're treated as a result of that is really gut-wrenching sometimes. So it's extremely important work. It's why I'm so passionate about the work that IJ does, and why I'm, so happy to be here.
So what you said the highs are very high. What is an example of a high as a public defender?
Saving a client's life. I mean, winning at trial and getting them off. Even, just getting them a really good outcome through a plea deal sometimes is great as well. Pretrial motions, which we'll talk about today. Occasionally, not super frequently, but you do win those every now and then, and that can make a big difference in the case too.
Great. Well, we will get to that case later from the 10th Circuit. But now I am so happy to reintroduce to our audience Anna Lucardi is her name now. She was a fellow of ours a couple of years ago. She came on Short Circuit, I think 2 or 3 times in your brief time with us. But then she went on to big time clerkship. Now she's a big time practicing attorney, but she has taken some time to come back on the show. So Anna, thank you for coming back. And you have a case from the Fifth Circuit that it doesn't exactly involve the rights of the accused who can't afford their own attorney. I think everyone has heard the letters AT&T before, but just because you're a massive corporation doesn't mean you also perhaps have some jury trial rights, and that's what the Fifth Circuit dug into.
Yeah, Anthony, it's so fun to be back. Thank you very much for having me, and I'm happy to be here today. And so, yeah, with that, let's dive into the Fifth Circuit.
Great.
So this is a case called AT&T Incorporated versus FCC, not the most original name, but it's an interesting one, and it does, as you said, it goes directly to the Seventh Amendment and also some Article 3 issues as well. So for the constitutional law lovers out there, which I think many of your listeners are, it's a good one to chat about. So this case particularly arose out of a FCC fine that was imposed on AT&T for violating Section 222 of the Telecommunications Act. And the panel was Judge Haynes, Judge Duncan, and Judge Wilson. And Judge Duncan out of the Fifth Circuit actually wrote this panel, and it was a unanimous decision. And Judge Duncan really started it out kind of by just really walking through first of all, what is Section 222? And so just to give us a quick background, because I personally was not very well versed in this section, it is the section that protects what they call customer proprietary network information. So obviously, when you have these telecommunication common carriers, they're dealing with a lot of personal information. That's the data that's being transmitted. That's the location data of their customers. That's the amount of data that their customers are using. And it's very important that that data is being protected. And so with that, what they've implemented are regulations that basically say that these carriers have to take reasonable measures to discover and protect against unauthorized access, and they can only use or disclose that information, which they call CP&I, with opt-in consent from users. So basically, unless it's being used to actually provide the service, the only other way that you can use it is if you are getting opt-in consent. And a lot of the factual background here isn't super important to kind of the main issue and the Seventh Amendment issue, but basically what happened at a high level is that AT&T has these location services. Obviously, we all on our phones have these different apps and things that use our locations, and that's something that is very common. But the way that they were giving permission for third-party applications to use location services, the FCC said, well, that's not quite up to snuff. There had been some information that came out about, well, actually, maybe police are getting access when people haven't actually fully opted into this information, if they have a warrant. A bunch of different concerns had come up. And so the FCC decided to investigate. And that brings us to their system for handling these types of violations of Section 222. And there's under that section, there are kind of two ways that they can approach this. Either they can assign it to an administrative law judge, or they can keep the investigation in-house and they can investigate it and adjudicate it fully on their own. And not surprisingly, they tend to choose the latter option. So when they do that, the process is that they can, however they become suspicious or concerned, whether it's a report, whatever happens, it's not really clear here kind of what initiated their concerns. I know there were some news articles around data being shared. And so they start looking into it. They launch an investigation. It gets assigned to their investigations bureau. And the FCC basically decides, oh, we think that there was a violation here. So if they think that there is a violation, they then issue something that's called a notice of apparent liability, or an NAL. And once they issue an NAL, that goes to the carrier. So AT&T gets this notice, gets told in the notice, hey, we think you're violating in how you're using location data. And also in that same notice, they get told what the fine they are expected to pay is. And the fine, the commission has a lot of discretion in determining what that amount of the fine is. They can consider a wide array of things. They consider the nature, circumstances, extent, and gravity of the violation, degree of culpability, prior offenses, ability to pay, which obviously in the case of AT&T, they recognize they have an ability to pay. And they also have discretion to consider any other matters as justice may require. So their discretion here is basically pretty boundless. And in this instance, which is kind of a flag in and of itself. And as we go further, I think the court had some concerns about that as well. But so here they awarded a fine of $57 million against AT&T. So after that happens, this is where the system gets kind of extra fishy and where AT&T really focused its arguments that we're going to get into in a minute. After an NAL is filed, the carrier against whom it's brought against only gets to respond in writing. And so in the investigation prior to the NAL, the government has the ability to request documents. They get to bring interrogatories. They can even use administrative subpoenas to kind of require depositions, those sorts of things. There's not much power at all for the carrier. And then after they now have this noticed against them, their only way of responding is they get one shot to write a response and say, well, these are the reasons why this is actually incorrect and we shouldn't be fined for this. AT&T did that here. The FCC was unpersuaded, not surprisingly, since they are the ones that issued it to begin with, and said, no, that's great, that's good, we're leaving this in place, you owe us $57 million. And at that point, that fine becomes final, and AT&T owes them.
And also all of this at this point has just been before the agency. It's not even like a separate kind of agency judge.
It's not even a separate agency judge. It's just the commission sending out this notice saying, we think you owe this, and then saying, no, we disagree with your reasons that you say you don't owe this. So it's all very much in-house, kind of one-stop shop in a way that definitely raises some constitutional concerns.
Yeah.
And so at that point, there are kind of two paths, and Judge Duncan really takes some time to outline this as background as well, of either they can not pay the fine. And if they don't pay the fine, it basically goes into collections and it goes over to DOJ, and DOJ can pursue an action against the carrier, against AT&T. And at that point, you get a jury trial, which sounds great, except you're not able to challenge the legal basis for that award. So you're kind of hamstrung, and all you can argue is, so for example, with the location services, all AT&T could argue is, hey, we didn't actually wrongly share location services. They couldn't make any arguments about, well, as a matter of law, the behavior that we did wasn't a violation. So obviously in court, and particularly when you get to the Court of Appeals and things like that, very often the legal arguments are kind of the linchpin of what you want to do. And so to take that away and make you choose, you can only argue the factual bases, is very problematic and isn't letting you have a full and fair trial. That's not actually an option for that.
Right.
So, and also not to mention, to get to that, you first have to go into collections, let that set there. People are going to know when you're dealing with companies like AT&T, that's going to be very public. It's going to affect your business. So there's a lot of problems with kind of taking that route.
And that could just sit there for years, like a judgment against anyone.
And you have to wait for the DOJ you can't go bring that action.
Right.
So you also are left in this kind of balance of, well, that judgment's hanging out there, but DOJ is not taking action on it. Where do I go from here? So the other option, which is what AT&T did in this case, is that you can go ahead and pay the fine, and then you can take it up with the circuit court. And so that's what they did in bringing this case to the Fifth Circuit. And that kind of brings us to where we are here in this opinion. So AT&T raised a variety of arguments, but there really are kind of two that the court focused on and took up and said, this decides all of it. And those had to do with the Seventh Amendment and Article 3. And spoiler alert, the court really did not think that the FCC's process comported with either of those. So to start with the Seventh Amendment, which is where a lot of the analysis really focused, the Seventh Amendment is the right to a jury trial and provides that you have a right to the jury trial in suits at common law where the value in controversy exceeds $20, and that's basically it. Then you get the right to a jury trial. And so the court honestly did a great job of kind of laying out what you want this analysis to look like. I really enjoyed reading it, and I think they did a great step-by-step approach of what this should look like. And they broke it up into two steps of talking about, let's look at the nature of the cause of action and then the nature of the remedy provided. And they flipped it and started out with the nature of the remedy, which they really emphasized. And I should step back a second and say a lot of this analysis comes from last year. The Supreme Court decided a case, Jarkesy versus the SEC, which also came coincidentally out of the Fifth Circuit. And dealt with when the Seventh Amendment applies and kind of these administrative proceedings and really guided the court here.
We at IJ were very much watching because we have a couple cases like this in smaller clients, but involving jury trials and fines and all that.
Yeah, and when I was at IJ, I got to work on a case in Indiana dealing with jury trial rights kind of in the forfeiture context as well.
Right.
And this is such a fascinating area because there are so many areas that it feels like it should be intuitive that the stakes are so high, you should be getting a jury trial, and yet there's kind of these gray areas in how the case law has developed. So here, the court really just did a very practical analysis. And so they started with looking at the remedy, and they said, look, civil penalties are, and they called it a prototypical common law remedy. Like, this is kind of as common law as it gets. They're not remedial. They don't restore the status quo. And they also, because another factor that can come in here is this something where you're basically trying to, in equity, restore somebody to what they lost. But this money is going to the government. You're not giving it back to these clients or in some way trying to compensate them for the data that's being taken.
And suits in equity famously just don't have a jury. Maybe you should get an independent judge, but you don't get a jury.
Exactly. So that all comes into and kind of the separate Article 3 question of whether, regardless of if you get a jury, should you at least be in a traditional Article 3 court as well. And so they were pretty quick with that analysis and basically said, this case, it's the same as Jarkesy as far as this is concerned. Like, this is an issue where it's a common law remedy, it's a civil penalty, it's a common law cause of action. And so then it's a common law remedy. And so then they shift to talking about the nature of the cause of action itself. And they start by kind of critiquing the government a little bit for not making more of an argument about the remedy and only focusing on the nature of the cause of action, which I thought was kind of interesting. But the court very much took the view that remedy is very important. That said, they then went ahead and addressed the arguments that were raised as regard to nature of the cause of action and pretty much just said, look, we're not impressed or even slightly influenced by any of this. The key to them was that the nature of the cause of action is that this was very similar to a negligence cause of action. And they were clear that it doesn't have to be identical, but this is something where you have a company that they are not taking a precaution that they have a duty to take, and that they are therefore liable as a result. And the court said, look, that is just negligence repackaged. And the commission tried to say, well, this is very technical. And the court said that couldn't matter less for negligence. It's still a negligence adjacent situation. That's still the type of cause of action. And again, negligence is a fundamental common law. If you look back in history, we'd be very hard pressed to say that this is not a common law, not a suit in equity when you look at the history and the context, which I think is, again, just a very practical interpretation of it.
Although I would say the court doesn't get into this, I would say negligence itself actually did not exist by the 18th century. It was like a 19th century invention, but it's still in that tradition of tort for wrongful conduct. They just didn't really have it be negligence back then.
Right.
But
they didn't.
Anyway, that's just something a legal historian I thought about.
No. And that isn't interesting that they shied away from touching on that. And they also, one thing they did talk about is, and tried to use, that the commission tried to distinguish this case from Jarkesy, was talking about the fact that Section 222 doesn't use negligence language. Versus in Jarkesy, kind of the statute there was more of a direct implication of like, oh, we're dealing with something in the family of negligence. Here, that affirmative language wasn't used, but it still was kind of in the spirit of negligence, and they found that was enough. So I thought that was a really interesting point with that as well. So they found, okay, Seventh Amendment applies. And then there is a right to a jury trial if you're going to impose these type of fines. And then they set that aside and shifted for a minute to Article 3 before Judge Duncan kind of circled back around to apply it to the facts of this case specifically. Then we talked about Article 3 are you entitled to a judge? And the way that the commission tried to avoid this was by saying, well, this falls within the public rights exception. Again, this was an argument that came up before the Supreme Court last year, and the Supreme Court was not fazed by it. And similarly, the Fifth Circuit didn't adopt it. They basically tried to argue that this is a public right. And so, again, private rights, you get an Article 3 judge. If you're dealing with a public right, then you no longer have that. And public rights, for example, some of the examples that were given by the commission are revenue collection, foreign commerce, immigration, tribal relations, things that very clearly historically fell within the purview of the executive and the legislative branches. This isn't that. And that was really what the court said, and again pointed to Jarkesy as just the clear indicator of that. This is a private action. It's punitive. It's punishing a company that has failed to comply with their responsibility. It just doesn't fall within this. And they were actually really strong in their language on this point. And Judge Duncan said that he was concerned that it would be blowing a hole in what is meant to be a narrow exception for myriad enterprises if they were to say that this type of situation fell within that public rights exception. So they were very, very clear of, no, this is narrow. We're keeping it narrow. We think the Supreme Court intended for it to stay narrow, and we are not going to expand it any further. They also, within that, acknowledge, of course, the commission has the ability to take actions and to basically hold entities like common carriers accountable, but they have to do that in a way that comports with Article 3. So with that framework as the background, Judge Duncan wrapped it all up with a short and sweet coming back to the facts of this case. And the fallback argument for the commission was, well, if these things apply, then we comport with them. And the Fifth Circuit said, that's just not true. And that brings us back to what we talked about in the beginning, right? Of there are two paths forward, two ways to get review, and neither one is sufficient. Either you get a jury, but you can't make your legal arguments, and you can only do it after suffering the consequences of basically going into default and relying on the DOJ to take action. Or you get to come to the Court of Appeals, but you never get your jury trial. And at the end of the day, the Fifth Circuit said that is just not getting your day in court. That is not getting the protections that you're entitled to, either under Article 3 or under the Seventh Amendment. And so it was a win for jury rights. And I think while AT&T is certainly not the most as sympathetic as many an IJ client, I think it's, as a principle, something that's very important and a good result to see as well.
Well, Jessica, doing public defender work, I'm sure you're familiar with juries. So your thoughts on all this?
Absolutely. Yeah, one thing that struck me that I think the court discusses in the remedy context, but doesn't expand on, is who's getting this $57 million, right? Like, it's not going back to the quote unquote victims of this violation, right? Like, am I wrong to assume that it's going back directly to the commission?
That's my understanding. I know it's going back within the government, and I would assume, yes, it does seem like it's a pretty self-incentivized program for sure.
Yeah, I wonder if it's going back into their budget, but that's a whole nother
That's
question,
a whole
course,
other
like civil
question.
forfeiture.
Yeah.
Yeah, and you describing in the case, I was reminded of there's a famous. We'll put a link in the show notes to it. There's a famous passage in a article by Gary Lawson, a law professor, who in 1994 who wrote about basically how the modern administrative state is unconstitutional, and there's a paragraph that a Justice Anderson, Barry Anderson, who used to be on the Minnesota Supreme Court. I know him locally here in Minnesota, and he loves reading this when he gives a speech, because it just shows how the lack of separation of powers often in the administrative state. And I won't read it right now, but we'll put a link to it. But it's basically how the commission refers matters to the commission, for the commission to prosecute, for the commission to then hear before the commission, and then you can appeal to the commission, and on and on and on. And at the end of the day, you can kind of get into court, but that at that point, everything's settled. And so it seems like the Fifth Circuit is saying, yeah, that's just not going to work anymore.
Yeah. I think it seems like that goes with kind of the sea change that we're seeing and what the Supreme Court is signaling. So it'll be interesting to see. It's interesting to see Jarkesy being applied, and it'll be interesting to see where it goes from here.
Yeah, there definitely is going to be some percolation with Jarkesy, and not just the IJ cases in this case, but other cases, and see how broad it becomes. One last thing on the Seventh Amendment. So I was just reminded of this because I was at a conference when a speaker raised it. Do you know what the $20 in the Seventh Amendment actually referred to? Jessica, you seem like you know this.
Well, no, I wasn't going to say the $20. I was going to say what it is equivalent to today, which is also a fun fact. I think it's like $750 or something like that. Which
oh, really? It's only that much?
It's not as much as you would think.
I would have thought it was more. Wow. But no, what is it?
So I guess what it actually, because when they wrote, they hadn't really started the U.S. dollar yet at that point, as we know it today, or as it later became with the Bank of the United States and that. So it actually referred to like Spanish silver dollars, and they were called dollars, but they were in circulation, and that was kind of like, what people meant by a dollar. I don't think that like changes the value, how we think about it, but that if you were like, well, you have $20 if you had a bag of 20 pieces of silver, then you would have a right to a jury trial. So
interesting. I'm going to keep that one in my back pocket for Jeopardy someday, Anthony. I think that's going to be my winning.
Maybe
winning
double check.
Answer.
Maybe any listeners, you might want to double check that. But anyway, I've heard it a couple other times elsewhere. At some place. Well, we're gonna shift now from extremely large corporations to ordinary folk who did things they were not supposed to do. But nevertheless, they have rights under the Fourth Amendment, the right to be free from unreasonable searches and seizures, but also the right to be free from warrants that allow general searches. So, Jessica, if you could tell us about this case.
Sure. Yeah. And I think, me and Anna today are in a battle of maybe the least sympathetic clients. I'm not sure who will win. We'll let the listeners decide that. But this case is U.S. versus Alexander William Santiago out of the 10th Circuit. It was on appeal from the Western District of Oklahoma. And as has been alluded, Mr. Santiago is not the most sympathetic of folks. He was 24 years old and had been alleged to be engaging in a relationship with a minor. The minor's mother reported Mr. Santiago to the Oklahoma State Police, and they arrested him and took his phone. So a couple weeks after that, the Oklahoma police tried to obtain a warrant to search that phone. And the warrant essentially sought, call and text information, but then also, quote, any other information within said phone that may be deemed evidence that a crime has been or is about to be committed. And as we know, the Fourth Amendment is quite explicit about the particularity requirement. You can't just search anything for any reason to find some evidence of a crime, right? You have to be specific about what you want to search and why, and what the parameters of that search are going to be. So clearly, this warrant had some issues. Nevertheless, the magistrate approves it, and the phone is searched, which uncovers some what we'll call incriminating images that Mr. Santiago was in possession of on his phone. So that case regarding the incriminating images is referred then to the feds. So the feds then get their own warrant and search the phone and use that evidence against Mr. Santiago in the federal case.
Why, by the way, just knowing criminal procedure, why did the feds need a separate warrant? Is that a jurisdictional thing, maybe?
I assume it was just probably for their own purposes to make up their own case and maybe not rely on the state so much. I was mostly in state court. I was the one who typically would have cases who the feds would take away from me. And sometimes that was good news. Sometimes that was bad news. But
sure.
I think it's probably just their own internal procedure. And maybe, as we'll see later in this case, to try to fix some of the mistakes of the state court folks, which... I'm not maybe ruining the end of this, but unsuccessfully so here. So the case is brought federally. Mr. Santiago files a motion to suppress, which is denied. He's convicted on the federal charges and sentenced to, I believe it was 30 years in prison. So quite a bit of time there. On appeal, he argued that the evidence from his phone should have been suppressed because the warrants used to search his phone were unconstitutionally or were constitutionally deficient, we should say. So the lower court agreed that the warrant was constitutionally deficient and, said that it's too broad, that's not valid, but the good faith exception applies. So I guess I should maybe back up and explain first the exclusionary rule to the listeners. Basically, that rule says that evidence that's obtained illegally can't be used against the criminally accused, right? So if you, violate the Fourth Amendment, you can't then use that information obtained against someone in their criminal trial or in pretrial motions. The good faith exception, however, is just that, an exception to the exclusionary rule. So I like to think of it kind of, in law school, we learned ignorance of the law is no excuse. Well, I think the good faith exception kind of turns that and says, well, ignorance of the law is no excuse unless you're a law enforcement officer, right, who's tasked with enforcing the laws. And it defies logic, really, to say that the folks who are tasked with enforcing the laws don't need to know the law and kind of are given a free pass, but everyone else on the street, they can't use that as an excuse. So off my soapbox, regardless, the good faith exception is there. And
no, we are a soapbox, so that's fine.
the alternate name for the podcast, soapbox.
There you go.
But yeah, I mean, the good faith exception says, if the officer didn't mean to violate the law, then it's okay. We'll let the evidence in. So the lower court found that the warrant was too broad, but that the officer didn't mean it, and we should let the evidence in regardless. So here, the 10th Circuit kind of takes up two issues. One was whether the good faith exception does in fact apply, and two, if you remove the information from the state court warrant, does the federal court warrant survive? So first, I guess, looking to the good faith exception, the government argues 2 points here. The first is that everyone admits the warrant was overbroad, but they said that you have to look beyond just the warrant itself to a totality of the circumstances to see if there's other factors that maybe, not stated in the warrant limited the scope of the search. And the court kind of plainly rejects this and just says, listen, this warrant was so blatantly deficient that we can't possibly look to other circumstances. Like, no reasonable officer would think that this was okay. So they kind of just get rid of that real quickly. Same with the second point. The government argues that, the point of the exclusionary rule is to deter police misconduct. And there's no police misconduct here because a magistrate judge signed the warrant, not a police officer. So how is this going to deter the police officer from doing anything wrong in the future? And again, the court says, good try, but that logic doesn't really fit. The officer was the one who drafted the affidavit, and the affidavit, is pretty much word for word the warrant, right? Like they're the same thing at the end of the day, and the officer's the one who drafted this. So, good try, but no, that's not going to fly either. So the 10th Circuit says good faith exception does not apply here, and then kind of turns to the federal warrant. So if you take out all of the information from the state court warrant search of Mr. Santiago's phone, what are you left with in the federal warrant? And essentially all you're left with is evidence that Mr. Santiago was in a relationship with a minor. And the case law is pretty clear that evidence of a relationship with a minor is not, in fact, probable cause for searching for incriminating images. So the law is not, in the government's favor on that one, and the court says so, and kind of bats away that argument as well.
I mean, because that reasoning was pretty chilling. Like, basically any couple would have bad evidence of their relationship. I hope that's not true of most couples. And maybe if you have a relationship like this where someone is a minor, maybe it's more likely, but that's not something that we can presume.
Right. And I think even in the court's record, I listened to the argument on this. They didn't have any photos in the record to even look to, analyze. They had descriptions of the photos, and they're pretty, I say innocuous. Like it's just, you can tell that they're a couple, but there's nothing explicit about the photos themselves. So that's kind of, the government has no real leg to stand on in terms of saying that they tried to say that those photos were indicative of more, but I think that the court's just not buying it.
Right.
So overall, the court reversed the lower court holding, vacated Mr. Santiago's conviction, and remanded the case back to district court. Really why I wanted to do this case was that it's kind of a unicorn. I mean, the law was absolutely in Mr. Santiago's favor, but the facts were not. And as I, am well aware from my experience, sometimes you can have really great law, but the court doesn't want to let someone like this back on the street, right? And they'll kind of do whatever they can to make sure that he stays behind bars. So this was kind of one that baffled me a bit until I listened to the oral argument, and there I think lied the kind of I don't know. There was a light bulb that went off for me, because the first question that the panel asked of the government attorney was, "So what's the status of the state court charges against this guy?" And they were like, "Oh, well, they're still pending." So this guy's still going to prison probably for life on the state court charges. And I think that maybe gave the judges, a way to rest easy at night, knowing that they could overturn this and still have him maybe be responsible on other charges.
Is that because the state court charges aren't just this possession of these images, it's the relationship itself or whatever?
Correct.
Else?
Right. Yeah. So he has some statutory
yes.
issues there in the state court context.
Anna, your thoughts about this in the Fourth Amendment?
Yeah, I mean, it's a fascinating, because I clerked in the Northern District of Oklahoma as well. I always think it's interesting when it's cases kind of coming out of there and out of, I don't know if this was a McGirt case, but kind of there's such interesting dynamics with the dual prosecutions in state and federal there, and with how that kind of interplays with Fourth Amendment and with protection of defendants' rights. And I mean, I agree with Jessica. I think that it's a unique case in that it sounds like the judges really were able to separate out the facts and what are pretty egregious facts from just the reality of, okay, what matters at the end of the day is a rule for one person is a rule for all, and that's why the rule matters. It's not about a particular defendant. It's about having uniformity of application so that whether a defendant is sympathetic or not, the rights are being protected, and that is incredibly important. And I think it's admirable that it sounds like the court got it exactly right of being like, we defend, our job is to make sure that the rights are protected. The facts are not really the issue in a situation like this. So I think that's wonderful to see. I also, as you're talking about their argument about, the judge, and the judge is the one that signed the warrant, also makes me think of IJ and a lot of conversations that IJ has about questions of absolute immunity for judges. And should there be some responsibility there as well if a judge is kind of rubber stamping a warrant that should be arguably as clear to him on the face as to the police officer that maybe it is insufficient. So that was my other kind of thought on that as well.
Yeah, I think as to your first point, one thing that as I'm sure many public defenders ran into is, people come up to you and ask, like, how can you defend someone who's a criminal, right? Like, how can you defend someone who's done terrible things? And I think the answer is, like, it doesn't matter what you've done. Everyone is entitled to the same rights, right? So it's not like you can pick and choose who gets constitutional rights based on their actions. That's not how our Constitution and our country works. So I applaud the judges for being able to parse that out and look beyond these facts. I think I am maybe a bit more cynical to say that they did so because they thought he'd still be behind bars, but it's just me.
I was really struck by the language. I mean, I think this is what struck the judges too, is the wide open language at the end of that warrant that you read earlier, because there's so much on the description before that that was probably fine for their purposes. So all call information, voicemail, call logs, text messages, on and on and on, like everything basically you would have on a phone. And then as well as any other information within said phone that may be deemed evidence that a crime has been or is about to be committed. It's like they are writing interrogatories to the other side, like, and anything else, like something you'd ask in a deposition, but instead it's a warrant. I mean, if you had a warrant to search a house and then you say, and anything else in the house that might be, evidence for a crime. Well, I mean, that's a general warrant for the house itself.
Yeah.
What is that? Do you think that's, I mean, knowing the system better than we do, Jessica, do you think that's common, or did this just one office where maybe whoever was typing this up, kind of got away with themselves? Maybe they put it in a few other warrants and then they never was checked, because it just seems so blatant.
Yeah, it's hard to say. I can't say that I saw this language in my career, in looking at warrants and evaluating cases, but it wouldn't surprise me. I mean, I imagine, officers probably like other folks, right, are just kind of regurgitating what they've seen done before. So if it's worked for one person in that department, they maybe just use it again and see how long they can get away with it. Who knows? It's probably more prevalent than we'd like to think. Yeah.
Are warrants pretty standardized when, you have a general search warrant for a phone or for a house, for a car? Or is there a lot of wordsmithing warrant per warrant?
I always found that they're pretty much just templates that are regurgitated.
Yeah, well, interesting. So Anna, I had forgotten that you had that stint in Oklahoma during McGirth.
Yeah.
Do you want to just tell us a little bit about that, and maybe what you know, maybe how things are now, because Congress has not acted since that happened. So I'm guessing they still have the same situation.
Yeah, I think so just as a quick background for listeners, the McGirt decision that came down, I think it came down in 2020,
yeah,
I want to say, because I started clerking in 2021, kind of right as it was kicking up. But it basically resulted in a large portion of Oklahoma being found to be Indian land. And so with it being Indian land, a lot of prosecutions that would generally and typically be state prosecutions became federal prosecutions. So that meant a lot of people had to be retried. A lot of new prosecutions that would normally have belonged to like the district attorneys and state public defenders now were federal PDs and AUSAs. It meant that the FBI was investigating kind of run-of-the-mill crimes that normally, again, would fall within the state police department's purview. And initially I think judges that I knew their dockets tripled, the federal judges tripled in like a year or so, in a way that was just kind of unheard of because of the shift over. It made it a very interesting time to clerk there. It meant that whereas traditionally in federal court, you're not seeing that many trials, like there were trials all the time.
A lot of late nights for clerks.
This year, some late nights for clerks and lots of, it was definitely an interesting time to be there. I think it's gotten somewhat better now. There have been some follow-on cases that have kind of cleared the way for dual jurisdiction. So some of the things that now are back within, the Supreme Court has since clarified, hey, in certain circumstances, the state is still able to prosecute cases as well as the federal government. And obviously you can't get into double jeopardy issues or prosecution for the same crimes, but it's possible for the federal government to kind of opt out and let the state handle some things. I think that's helped. And Oklahoma has also, I believe, in the last few years gotten several new district court judges, which I think has helped to correspond with the need for, there's just a lot more cases, and for the foreseeable future, there's going to continue to be more cases. So I think it's gotten better as the state has kind of adjusted to a new normal, but it definitely shook up the landscape, and it was a fascinating time to kind of be there in the midst of that.
Well, great. Thank you both for your summaries this week. We are now, though, we're not done. Listeners are very excited that we are now going to have a little bit of Where Are They Now?, with some of the cases that we've discussed in previous episodes. So just a handful to update people on. A lot of cases that we've discussed in the past, if they didn't just end on appeal or get settled, they then get to the Supreme Court, and the Supreme Court, this is the time of year where you have a lot of rescheduling. You do have some cases being resolved, though, some denials. And so we have a little bit of update about that. So one case we talked about a while ago now, our friend Kermit Thomas West gave a report, is McCrae versus Matos. This is a case about a public school teacher who was fired for stuff she did on social media before she was hired that was only later found out about. And basically they were like conservative memes is what she put on there. And so is that covered by the Pickering standard for First Amendment speech by public employers? And that has been rescheduled 4 times in the last month and a half at the Supreme Court, like whether they're going to make a decision about the cert petition. So that seems interesting. They're trying to figure something out there. That may be they may have a denial or a grant really soon, but they may keep it till the end of the term. Then a couple others. One is we discussed a few months ago a case at the Sixth Circuit that it was actually a mootness decision. It said the case was moot, but it was about this long-running battle to try to get a qualified immunity reform initiative on the ballot in Ohio. And the attorney general there is not a fan of ending qualified immunity in Ohio and is doing everything he can to get it off the ballot. Finally, in the latest lawsuit, it went to the Sixth Circuit and there was an injunction to say you have to put it on the ballot. Went to the Supreme Court, and there were 3 judges who would have stayed the injunction, but only 3. And so it is now going forward, and it looks like it will actually be on the ballot this year, which makes things interesting. Although I'm sure there's going to be more litigation, procedural litigation about it. Finally, we talked about a case. Our friend Bert Gall, I think, discussed this case in our Christmas sweater episode right after Christmas last year. And this is the case where there's a voting rights challenge in Virginia that tries to use this statute from Reconstruction about when Virginia can change voting laws in its state constitution. Really interesting theory, and it's not on the actual merits yet. It was a procedural matter, but anyway, that has now gone to the Supreme Court, and a response has been requested. So someone's interested in it. So we'll see if that gets any more. That's all for now. I'm sure we'll have more as the term kind of winds down into June. We'll have a more full-throated catch-up on some of our previous cases. But right now, it has been great to catch up with Anna. It has been wonderful to have Jessica on for the first time. I'm sure you'll hear from both of them in the future. But for now, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all the other podcast platforms. And remember to get engaged.